names of everyone in the room there. Let me know who you're representing here today, whether you're the applicant, the owner, or someone else. So I will start up with JP's room there. JP, if you could do some introductions.
Yes, good afternoon, Mr. Examiner. Can you hear me okay?
I can.
As you know, I'm JP Burley. I'm an attorney with Suter LLC. I'm here on behalf of the applicant and owner, Mr. Khaled Saba, who's sitting here to my left, your right. I have his nephew, is that correct? Motaz Saba, who assisted in some of the work on the site plan, and our law clerk, Maddie McCabe, who's a law student at UC.
Okay, great. Will the nephew be participating in the hearing here today, providing testimony?
He's available to answer questions about the site plan, but I anticipate that Mr. Khaled Saba will be our primary witness.
Correct.
Okay, great. Could you just state his name again and spell it for me?
It's Motaz. First name is spelled Mohtaz. M as in Mike, O as in Orange, H as in Henry, T as in Tom, A as in Apple, Z as in Zebra.
Okay. And your last name?
Same last name, Elsabagh. Elsabbagh.
Got it. All right, great. Thank you. All right. Are we expecting anyone else to join us here today before we get started on the applicant owner side?
None from my side,
No.
Mr. Examiner.
Great, thanks. We also have Wes Munzel here from the planning department. Welcome, Wes.
Good afternoon.
Okay, let's go ahead and get started. I'm going to read through our hearing script. This will just cover the procedure for the hearing, and then we'll begin. So this is the January 29th, 2025 session of the zoning hearing examiner docket. Again, my name is David Starkey. I'm the zoning hearing examiner for the city, and I'll be presiding over this hearing. The case before us today is case number ZH20240165. The purpose of this hearing is to allow applicants and any other parties to testify and to offer and refute evidence and testimony. This hearing will follow rules found in the zoning code and the supplemental rules of the zoning hearing examiner. All testimony and evidence that an applicant or any other party wishes to offer must be presented at this hearing. The hearing will proceed as follows. The applicant, the applicant's attorney, or the applicant's agent will first present the applicant's case. If we did have any members of the public here, they would have an opportunity to speak after the applicant had presented its case. I'll hear from the planning department and Mr. Munzel to provide any testimony in addition to a staff report. In the event that any party testifies or offers an argument in opposition to this application, the applicant will have an opportunity to respond to that testimony that was offered in opposition. And then finally, the applicant will have an opportunity to make any closing statements. After all presentations have been made, I will close the hearing. Decisions may be expected within 2 weeks. I may limit or exclude any testimony that I deem irrelevant or outside the scope of the application being considered. I may interrupt any speaker to ask questions or make any comments. In the event of any technical difficulties with the Zoom some defect that prevents us from meaningfully going forward with this hearing, I may continue or postpone the hearing at my discretion. Okay. Last thing I need to do is to just swear in all of our witnesses. So if you intend on providing any testimony here today and are not an attorney, then the zoning code requires that I swear you in. So I'll do that now collectively with everyone. And Mr. Motaz, if you anticipate, there we go, doing anything at all, I think you can just be sworn in now. So I need you all to answer out loud. Do you swear or affirm that the testimony you shall provide will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Yes.
I do.
Okay, great. Thanks, everyone. Mr. Burley, are you ready to proceed?
We are.
Okay, the floor is yours. And Ms. Burley, as you know, I'm pretty liberal about how you want to orient your presentation. So if you want to do sort of your standard direct examination style questions, or if you just want to allow your clients to just testify and give some comments, whatever you're comfortable with, we can move forward that way. So again, the floor is yours.
Thank you, Mr. Examiner. I think I'll give just a general opening statement to set the floor for what we are here to do today. And Mr. Saba is here to answer any questions you might have, but we would rest on the evidence and argument we've put in the written submission already. So just by way of background, Mr. Saba operates a used car sales business called KS Used Auto Sales Inc. Now, he's been operating at this property in question since 2001. That was originally pursuant to a lease that he executed in 2001, and we've provided that in our application materials. From 2005 to 2015, he acquired the property in fee simple through a series of acquisitions. So now he now owns the property from 1919 to 1923 Harrison, 1927 K Street, and 1931 Harrison. In 2011 to 2012, the boundary for the 1931 parcel was adjusted because the city actually instituted eminent domain proceedings. They condemned the building that was formerly located on the corner, and they expanded the public right-of-way so that the property line for 1931 is now set back by several feet from the public street, and that is owned by the city at this point. That Mr. Saba has been selling used cars on this property consistently since 2001. In 2020, and as we explained in our application, that was originally a permitted use under the pre-2004 code when he began this use. However, in around 2020, some issues arose from an enforcement perspective. There was some confusion and disagreement between the city and Mr. Saba as to what zoning regulations applied at that point. And there's been an ongoing discussion to resolve those issues. So our firm was brought in, I believe, in 2023, and we applied for a zoning certificate for a non-conforming use for this operation. And I believe have had a very productive discussion with the zoning administrator and the zoning plans examiner since then to identify a few very minor items of outstanding zoning relief that, from the city's perspective, would resolve any issues related to zoning compliance. And I really appreciate Mr. Monzel's thorough report that I think methodically breaks down exactly what we have applied for. So it's really 4 items of relief. The first 2 relate to the 1919 to 1923 Harrison Avenue parcels. There's a conditional use for a carport that was constructed after 2004. Repairs will not be made inside that carport, and indeed repairs are not the principal use here. Mr. Saba does work on cars incidentally to selling them, but this is not a used car repair business. It is a used car sales business. So the staff report recommended that that conditional use be approved with conditions, and we appreciate that recommendation and ask that the hearing examiner grant the same. There's also a special exception for perimeter landscaping with respect to the 1919 to 1923 Harrison Avenue parcels. As I said, this operation has been in existence on this property since 2001. It's never had landscaping there. It's essentially in the same condition as when Mr. Saba started. So we believe that landscaping should not be required at this point, as it does not adversely impact anyone, and it's consistent with how this property has been used for quite some time. And the staff report did recommend approval of that item as well. So there are 2 remaining items of relief that relate just to the corner parcel at 1931 Harrison. The first is a conditional use for the principal land use, vehicle and equipment sales and rental. As I mentioned, there was a building there before, so the prior non-conforming use that affects the rest of the property does not apply to this particular parcel. The building, I believe, was only torn down in roughly 2012. So a conditional use is required in order for Mr. Saba to store cars there to be used in connection with the overall business. The staff report recommended approval of that item with conditions, and we appreciate that as well, and would ask if the zoning hearing examiner grants it. The fourth item is
real quick, JP.
Yes.
So it looks like each of these are sort of recommended for approval. The first three that you've talked about with conditions are, is your client in agreement with the proposed conditions?
The way we interpret these conditions is essentially that the operation will proceed in accordance with the site plan. I don't see any of these conditions as departing from what was actually submitted.
Okay.
For example, condition 3 is that the parking area at 1931 Harrison will be surfaced with an approved parking surfacing material. On the site plan, we indicated that it would be paved with concrete. Perhaps the only item that is different or not necessarily indicated on the site plan is the barricade that would mark the edge of the parking area for 1925 and 1927. But my understanding is that that's acceptable to
You mean the line?
behind your building. They just want a fence there to mark where the parking area stops.
Well, I got fence on the back, all the way on the back. I've got to put another fence in front.
There is
There
a
is
fence along the
there is fence all around.
perimeter, down the hill.
I think they wanted farther up to indicate where the parking area itself stops. Is that something that we'd be open to?
Can it be striping rather than moving a whole fence just to show where the parking stops? Because I mean,
There is a concrete that's down there, and there is a gravel behind. We park the car, where's the concrete up? That's what,
I think we're in agreement, it's just the move of the fence might not make sense if we can just show it by striping, stripe the area to show where the parking stops. If that's if that
Real
might
quick,
make sense.
let me allow Wes to jump in here. Maybe he can clarify exactly what the condition is. You can respond to that.
Thank you. I think that the condition is related to the gravel area that's shaded as red to the west of the 1925 address. So that we were wanting to have a barricade between the gravel and the paved area so that the creeping or movement of cars that are for sale is just on the paved area, not on the gravel.
Wes, do you have the, excuse me, do you have the site plan on your computer handy right now that you could maybe share your screen and visually?
I don't
Show
have it.
us.
I have to open up that file. So
Okay, I can share mine, but I just won't be able to control the cursor. So let's see if this works. Okay. So what's we're talking about 1925 to 1927 right now.
yeah, the kind of the reddish triangular shaped that area where the cursor is, that it says gravel there.
Mm-hmm.
The intention of the condition was to barricade demarcating the gravel and the concrete so that the storage of cars is only on the concrete surface, not on the gravel.
Got it.
Is there any way that we can mark it other than relocating a fence, but striping or anything else that? I'm just wondering if there's an easier, way to get this done rather than relocating the whole fence forward.
Well, I mean, it just says the word barricaded, so if there's some other method that you might think would be feasible to control or, prohibit cars from being driven into the gravel area for, that's kind of expanding the use that's allowed to the gravel area. If there's a way you want to propose that would accomplish that, then that's probably something we could look at.
Go ahead. Mr. Examiner, we suggest perhaps instead of a barricade that just concrete bumpers be installed, which is a normal way to indicate the edge of a parking area.
Exactly, similar to the curb stops you'd see at the edge of parking, if we might be able to utilize those, which might be a much easier route than relocating a whole fence line.
Wes, just to be clear, the intention of the condition is to prevent any parking on gravel surfaces on that lot.
That's correct.
Okay, gotcha. Okay, I think I understand the condition, and I think I understand the position of Mr. Saban.
All right, then the fourth and final item that we have requested relief from is the parking lot landscaping requirements for 1931 Harrison. That we requested a special exception from that requirement, and the staff report did recommend denial of that item. So that's where I will focus my time, Mr. Examiner, on as that's really the only item where the owner and the city are not on the same page at this point. So the literal terms of the zoning code, section 1425-29B, I believe, would, or it might be A, would require a 5-foot wide landscape perimeter encompassed by a 6-inch concrete curb, as well as landscape trees within the landscape area. And there's a ratio of trees per number of spaces, as well as trees per distance of the landscape perimeter. We respectfully submit that that should not be required under the circumstances for the reasons we've already laid out in our letter. We do believe we've met the standards for a special exception. The overall use that we propose here is compliant with the district's purposes. There's not going to be any impairment of property value, and we don't believe there's any likelihood of adverse impacts either. But just practically, it's helpful to look at the context here. This is not the entire lot that once existed at 1931 Harrison. A large part of that former lot has been taken by the city and is now part of the public right-of-way. So there is already an existing physical buffer, I would say, between the right-of-way and the parking lot area. And although this is not his property, Mr. Saba maintains that. He mows that area because it is important to him that this is a visually appealing gateway to his business. If the city wanted to install landscaping on that property that it owns, it should feel free to do that. But to ask that Mr. Saba locate that landscaping on his property in an already reduced lot size that's not adjacent to the street and that is not being required on the entire rest of his property we believe is an unjustified expense and would be out of character with the entire rest of his operation. So we would respectfully ask that that you grant a special exception from that requirement.
Got it. So is the argument, I mean, the argument is obviously that it meets all the conditions, but you're saying it's impractical to do it because there's simply not enough room on the lot, or it would encroach on space that is necessary for his business?
It would reduce the amount of space that he can use for parking, certainly. And also, we just don't believe it's necessary because this is not functionally right up next to the street, which is typically when that landscaping requirement would come into play. The eastern border of that lot does front on Harrison Avenue, but the northern border of that lot, which I believe is on Fairmount Avenue, does not front on the street. And there's a significant buffer already of city-owned property due to the eminent domain proceedings that occurred roughly 14 years ago. So we believe that if the city is concerned about what that corner looks like, the city could install landscaping on that corner without pushing that burden onto the property owner.
I'm gonna share my screen again really quickly just to make sure that I understand the layout here. So this is just your Google image satellite. It's I don't think there's any guarantee that this is at all current, but and maybe you can help me with that. But is the testimony here today that this portion of the property is not owned by Mr. Sabah, but instead by the city?
Not the entire unpaved area, Mr. Examiner. It might be easier for you to view this on Cages.
Actually, I'm sorry for interrupting. If you just allow me, there's a little fence that you can see. Well, now you can see it more clear. So
Okay.
that's the landscape buffer that he's talking about to the right of your cursor, that 20 feet or whatever that's landscape right now. So what we're trying to state is there's not much left for Mr. Sabah out of his property, as you can see within the fence line. And the fence already is continuous, obviously on the whole perimeter of both properties. So to require a 5-foot landscape buffer, I guess he would have to somehow jog back the fence right where you see the cars stop and go in 5 feet and just basically add 5 feet on both ends, which just sounds a little, I guess, unreasonable, given that there's already a landscape buffer right there on your right where the cursor is that is owned by the city. Yeah, that's about 20-25 feet, if not more. I don't know the exact number. But if you zoom out back to the aerial view, you'll be able to see where that fence line is and how much more right of way is out left. That could be a landscape buffer right there.
So
And-
Wes, I'm sorry, go ahead, Mr. Sabah.
I'm sorry, the whole area, 1931, it's only 25 feet on the corner, just 25 feet, and goes long, it's about 80 feet. When they took the city, like 10 feet in the front of the 25 feet, left 15 feet for that part for me. 15 feet by probably like 70 feet left over. You see, now if you take it from the 15 feet, 6 feet go back, what left from the 15? 9 feet. You know, all these arguments for 9 feet, I'm gonna put concrete on. It's been almost, like years and years trying to just put some little concrete on that part. You see, plus when they took the part, amendment, they took the building, I assume where you see that part of fence was whatever left over. I assume, like the lawyer he told me, all the parts of the land is fine. I put the fence on, and after 15 years, the city, they come with the violation. They said, I'm parking other lane. I wasn't paying attention anyway. But I got the guy, he did the survey, and he told me, no, this is what your limit is. And what I did, I backed my fence where I'm supposed to be. But, all this come by not attention to me, because this is the first time something like this passed me. But they, what left over from the property is not even enough, to do all that. I just, you judge what you want to judge. I'm getting tired of this,
If you allow me to just explain what his frustration is, when this all happened and the building was torn down and the eminent domain occurred where they took some right of way out of his property. He was never under the understanding that he'd have to go through all this trouble, and there was a little misunderstanding on his end where where he came back and. For some reason, they let him have to install the fence, which I guess it makes sense that it would be the owner's responsibility to conceal the property. He installed the fence all across the corner, and he was made aware that he was in violation, that there was right of way out there that he was not, I guess, in total understanding of. And he already had to relocate the fence to where you see it right now to match the survey boundary lines. So he's just a little frustrated that he's gonna have to relocate the fence for a second time to add that 5-foot landscape buffer that he's being asked to add right now.
Plus back then, it's supposed only, the city, they put the gravel on the land, supposed to be parking lot. That's what, was, when they took the building and they left the parking lot for me as a parking lot. They put the gravel on, they put the gravel twice, and they're supposed to be parking lot. And after 15 years, all this changed, and I don't know
So
what happened.
you see there the difference between the two shots from where he had misunderstood where the property line is, and he went back and per conversations, he ended up relocating the fence to where you see it right now, and now he's being told that he has to relocate it one more time to somehow leave a 5-foot buffer just off that corner on its own.
Yeah. Let me real quick ask Mr. Menzel a question here on this. Mr. Menzel, what is the requirement here that they're asking for on the special exception? As you see it, what would need to be installed by the owner to be compliant with that 1425 regulation?
Well, first of all, he would not need to move the fence. He could build the 5-foot buffer inside the fence along Harrison.
Is it just along Harrison?
Well, I think technically it would be also along the whatever the other road is there.
Here, Fairmount?
Yeah, Fairmont. So in addition, he would need to provide trees. I'd have to check the code real quick here. Specifically what that is.
So his options would be to move the fence back 5 or 6 feet, or to install a buffer on the other side of the fence, and it would need to run along Fairmount here and then along Harrison as well, 5 feet into the lot. Is that right?
Just the section where the new pavement would be. Where the existing pavement is, nothing would be needed. Just the
Okay, so
20 feet from there to where the fence is.
got it. Okay.
Mr.
Anything else you want to
Examiner.
add to that, Mr. Menzel?
I mean, I would just say that the distinction there is that it would be, we're asking that the current code, which is new, the new landscaping requirement, be followed compared to the existing conditions that were in place 20 years ago or whatever. For this new segment, that's the distinction there. It's new pavement, and that the landscaping requirement be followed. So, the city did change their requirements for parking lot landscaping a year ago. So that it's kind of quote unquote kicked it up a notch. That's
Is this a connected communities
yeah.
landscaping requirement?
I mean, the previous requirement was a 3-foot grass strip, and that's it. No trees. But the new one requires 1 tree per every 10 parking spaces and 1 tree every 25 feet linearly along the perimeter. So that would require, probably 3 or 4 trees now total along that segment. Plus
Got
the
it.
5 feet of you know, a mulch bed or grass or something like that.
Got it. Okay, and if you know, I mean, was the purpose of those new regulations to soften the appearance of surface parking lots? Or some
Yeah,
other things?
that plus I think there's some, you know, benefit for providing a little bit of shade for cars that are parked or people walking along that area, that ultimately the trees will grow a little taller and provide a little shade, and you know, kind of a couple of, it's, you know, primarily aesthetics and, you know, shading and softening, as you mentioned.
Okay, great. Thanks, Wes. I appreciate that input, and sorry, Mr. Burley, for going a little out of order there, but just wanted to make sure that I was clear on exactly the regs and the intent of the regs. So I'll let you respond to anything Wes said or continue on.
Sure, just our overall point here, Mr. Examiner, is that requirement might make sense if this was an entirely new parking lot that was being proposed, but that's not what this is. It is a very modest expansion of a prior non-conforming use. The area that is under proposal for an expansion is quite narrow. It was actually narrowed as a result of the city's actions to take part of this property by eminent domain. Although technically this property adjoins the right of way on Fairmount Avenue, it does not practically adjoin the street. There is already a buffer there. So I think there is a reasonable argument that the landscaping should not be required at all along Fairmount Avenue. And at most, you're talking about Harrison Avenue. And to require, 30 to 40 feet of landscaping along a parking lot that spans several parcels does not seem reasonable under the circumstances. It would frankly look out of place compared to what is permitted by right on the rest of the property and what relief the staff report has already recommended for the rest of the property. And again, we just rest on the arguments that we made in our written statement that we have satisfied the standards for a special exception with respect to this requirement. That's all.
Okay, and so, I mean, I understand your argument about the Fairmount portion because the city does own the property between the subject property and the right of way. But what is the argument not to provide landscaping along the Harrison Avenue portion? I think I missed that.
I think it's helpful to look at this entire operation in context. So if you were to look at the street view of the entire business, Mr. Examiner, we're talking on Harrison Avenue, we're talking about maybe 20% of the frontage, probably less than that. So it does not make sense from an aesthetic perspective to have an out of place very small landscape buffer that is not being required on the entire rest of the property.
If you allow me to add, if you look at that aerial with how cars are parked up at the frontage, what you're saying is basically just the last 20 feet of that parcel. Any cars parked there would be pushed 5 foot back with a little rectangular landscape area, which would just look funny and like they mentioned, it would just look a little out of line in that corner.
The city, they just took 5 feet in the front, my front whole Harrison Avenue. You know, this is, I think, 15 years ago.
Yeah,
They was doing the street.
That was part of the take. They also took a certain distance
Yes.
along Harrison Avenue and pushed all his cars back, where it made it a lot tighter for the car movements on the Harrison frontage. There used to be a lot more space where you could park and move cars in kind of the drive aisle between his office area and the frontage of the cars, so he's just mentioning that now he'd have to push a certain count of cars at the end, another 5 feet inwards, which would make the drive area between the front line of cars much more narrower. And I guess you'd have to look at the aerials to kind of understand where I'm saying, where you've got a little drive right behind the front line of cars up at the frontage of Harrison.
Yep, I see that. Have there, after hearing or understanding that the intentions behind the landscaping regulations, have there been any proposals, JP, from your client to attempt to soften the appearance of the frontage of the property? Whether it's 5 feet or 1 foot, I mean, has there been any discussion about that?
We have not had any discussion like that with the city, no.
Okay.
I'll just submit again, Mr. Examiner, that this is the exact same use that is being carried on and permitted on the entire rest of the property that's under common ownership and control of Mr. Saba.
Okay.
So although this is technically a new, it is a separate parcel. It is functionally a part of one business operation. And we don't believe it's reasonable under the circumstances to add that sort of expense and lessen the usable area of that one particular parcel. Particularly when you look at the character of neighboring land uses around here. This is right in line with other parking lots that you can see on Harrison Avenue, particularly to the north. If you're looking at impairment of property value and adverse impacts, Mr. Saba owns the property directly across the street that stands to be impacted more than any from the appearance of this lot. It's those there's some vacant lots, and I believe a row house directly across the street on Harrison Avenue. He owns those as well. And that was mentioned in the staff report.
Okay. Anything else, JP, at this time before I turn it over to Wes?
That's all the information we wanted to add in addition to our written statement already. But if you have further questions for the owner, he's here, he's available.
Okay. I may, but I think now I'll just turn it over to Wes so he can outline
Right.
some questions or some
Thank you.
some of his staff report. Wes, anything you want to
Not really. I think JP outlined the parameters at the beginning pretty well. I don't think I have any additional insights or ideas. The one idea I did have, though, not related to this really, is that perhaps the applicant could purchase the land between the new sidewalk, on Fairmont from the city, since it's kind of like a no man's land kind of thing, to, increase his land area, but, take over the use of that. But I would still encourage that any landscaping be installed, appropriately if you do that kind of thing. But I don't have any other specific comments on the case.
Wes, do you have any comments in response to the applicant and owner's argument that installing landscaping along only a small portion of the frontage of Harrison Avenue would defeat the purpose of the regulation and may look out of place and inconsistent?
I mean, there is an argument for that, but I mean, if we don't ever uphold our landscaping requirements, we'll never have any, enhanced landscaping. This is a corner location, so maybe it's more visible. So maybe a little more landscaping is more, we should have a higher standard. I don't know. I mean, there are other examples down the street where there are no landscaping for a parking lot. So, I mean, I think it can go either way.
Mhm.
You know, I-
Yeah.
it's obviously an area where there's no landscaping. So, like, but we feel like we have to require and uphold our standards. Otherwise, there's no reason to have the standards.
Sure. Okay. Uh, Thanks, Wes. I appreciate your testimony here today and your work on the staff report. I think I will turn it back over then to the applicant and the owners. Anything you want to say in response to Wes's comments or anything else at all? I know you want to submit mostly on your written materials, which is fine, but if you want to say anything else now, you can, or you could move into closing.
I think we can move into closing, Mr. Examiner. We understand and appreciate Mr. Munzel's concern about the appearance from the north. But we understand that the city has land use regulations for a reason. We just respectfully submit that the particular requirement for perimeter landscaping for this particular parcel that's being used in conjunction with a parking lot where that requirement is not in place, is not reasonable under the circumstances. And again, to the extent that the city has a legitimate concern about the visual appearance of the corner of Harrison Avenue and Fairmount, that's city property. So the city should feel free to maintain or install landscaping there as it sees fit. I do believe there was actually discussion at one time about Mr. Saba buying that area, but there was a disagreement about price. So, we are where we are at this point. So just for all the reasons we've explained here today, and for those we've set forth in our written statement, we do believe that the relief we have requested is in the public interest, and we have satisfied the particular standards for that relief with respect to the conditional uses and the special exceptions, and we would ask that you grant those. So thank you for your time, and Mr. Munsell, we appreciate your time. We appreciate Emily A. House working with us on this as well. So thank you so much.
Okay, great. Thanks, JP, for your time and your statements here today. I appreciate the witnesses' testimony as well. I think I'd like to spend a little bit more time with this one and just make sure that I understand all of the particular circumstances involving this case. And I think this is a good case to make sure that I do an on-site visit. Those don't require anything from the applicant or the owner. It's essentially a drive-by. Sometimes I'll get out and walk around and just get a better feel for the environment around the particular property. So I'm going to do that and take that back and make a decision. As soon as I have a decision made, I will put that in writing. As soon as I finish that, I'll put it into a PDF and email it to everybody who's in the hearing here today. So you all have a copy of that really just moments after it's complete. JP, you're familiar with the process, whether approved or denied, so I won't belabor those points. Yeah, I will do everything I can to get this out to you within the next couple of weeks. If you have any questions about the process or you want a status update on the decision, I'm happy to provide that to you if you want to reach out to me directly. Otherwise, unless there are any other questions, I think we will leave it at that. Thanks again, everyone, for your time and your testimony, and we are adjourned.